My name is Andrew Goddard, and I should say it's a real pleasure for me to have Brian joining me. Brian was Queen's Counsel and then the Senior District Judge in London for many years, in charge of the Business and Technology list.
Not District Judge, Andrew.
You'll have to speak up there, sorry.
Don't worry.
And I think it's fair to say that Brian, as both counsel and as arbitrator, dealt with disputes across most of the world, really, certainly Middle East, Africa, Asia, Hong Kong, and close to home, England and Europe. So thanks for making the time to join the discussion, Brian. As I say, joining us from Singapore is international lawyer Shourav Lahiri, who acts as counsel in numerous international arbitrations, again covering quite a large part of the world, from the Gulf really to Australia, including, I think, India, which is the country of your birth, I think, Shourav. And like Brian, and indeed like myself, you concentrate on major infrastructure disputes. Now, the tagline for this Virtual Law Virtual Summit is negotiating the new normal. And today we want to discuss what some at least see as the tensions that are surfacing in the practice of international arbitration, including investor-state arbitration, and to consider perhaps how the resolution of some of those tensions may lead to a new normal in respect, at least of some aspects of international arbitration. Now, about a week ago, I was watching a rather interesting, I suppose you call it webinar, headed by Lord Justice Flo, who's one of the English Court of Appeal judges who specialises in arbitration matters, and other eminent practitioners. And one question which came up was the question of confidentiality in arbitration. And putting it very broadly, and of course there are exceptions, especially when it comes to investor-state arbitration, but certainly in pure commercial arbitration, the general, but although not universal rule, is that those proceedings and everything about them is confidential to the parties. The public can't attend, and the matter can't be reported publicly. And one question which came up during this webinar I was watching was whether that was really a sustainable position, and whether in perhaps 5 or 10 years' time that might change. Now, I would therefore like to start by having a discussion about the question of confidentiality. And then the second question, which very much occurred to me in the light of the discussion I was watching, was the whole question of party-nominated arbitrators. If one goes to court, at least in any jurisdiction that I have any familiarity with, you can't pick your judge. You can't pick any of the 3 judges in the Court of Appeal. But in arbitration, parties can nominate, certainly where there's a panel of 3 or 5, they can nominate a person as they want, who they want to be their arbitrator, their judge. And that is, again, a question which I'd like us to look at today, because I think it's also a question which people are beginning to query. But let's go back, if I may, then to this very basic question of confidentiality. Why should international arbitration proceedings be private and confidential when court proceedings are generally open and generally transparent? Brian, you've sat as arbitrator, you sat as judge, you've appeared as counsel. Why is there this difference, and is it justifiable?
Well, if I can adopt the position of Lord Justice Gross in relation to the question of appeals from arbitrators and whether it's affected the common law in general, and that is that the court litigation, that's state litigation, and arbitration resolution are complementary. And they're complementary in the sense that an important section of commercial activity is able to take its disputes to what I believe is an independent tribunal, and that those proceedings will be held in private, and that privacy will be protected to the end of the proceedings and thereafter. In my view, if that protection is removed, an important universal set of people throughout a universal set of industries will be deprived of their ability to pursue their claims with that protection. And I believe that if it were removed, there would be a serious decline in resolution by way of arbitration, which would be to the detriment of universal detriment, and which is to be avoided. Can I mention one other point in this connection which troubles me a little? And it's when I was reading day in, day out about proceedings in the commercial court between an organization called PCP Capital Partners and Barclays Bank. And that litigation every day was being put in the public domain, and some of it was, using a neutral term, unseemly. Allegations of self-serving evidence, of deceit, of sexist behavior, and so forth. Now, the media and the press, as I say, put this in the public domain. If you turn the situation around, suppose, and there was no arbitration clause in that case, suppose there'd been an arbitration clause. I don't think that the parties would have had their disputes aired in public, and I don't think they would have been resolved to the satisfaction of the parties. So that, I think, is a very serious downside to the loss of privacy. And just one auxiliary point, nowadays it's not uncommon for vital information of public interest is exposed, put into public domain by whistleblowers and so forth. And it occurs to me that if that practice were to become more common, and I'm not decrying the practice, it's extremely useful and to be encouraged in certain cases. But if that were to be become a common practice, would the courts then intervene to prevent that information getting into the public domain? And that would be an interesting situation. I don't know whether there's been such a case where injunctions have been obtained to suppress results and evidence and proceedings in private arbitration. Sorry, I've gone on a bit, Andrew.
Well, not at all. Shourav, what's your take on this? I think you query how vital or confidentiality is to the parties. Certainly, I think in some of the recent studies which have been done, recent surveys which have been taken, confidentiality does not rank in the top couple of places in terms of why people prefer arbitration. Sure.
Yeah, yes, Andrew, and if that's right, and there is a little bit of a disparity, I think, between the ultimate user of arbitration, which is the client, and the other participants in the arbitration process, which are their party representatives, arbitrators, and arbitration institutions. So if you look at the most, I think the study you're referring to, Andrew, is the Queen Mary University Survey on International Arbitration. The last edition of that was 2 years ago in 2018. If you look at the headline points, it is correct that confidentiality actually ranks 5th in the factors of importance that parties place when deciding to choose arbitration over going to court. And Brian was talking about court processes, and we are looking at why would a party choose to go to arbitration? How important is confidentiality? The overall numbers give it 5th place after the most important being the ability to enforce awards cross-border, staying away from local courts, etc. But if you drill down into the specifics of how that position has been come about, you'll see that there is a disparity between how important it is for the ultimate user of the arbitration and those who are participants in the arbitration, thanks to them. So the client is ultimately the user of the arbitration. The rest of us are assisting them. We wouldn't be there without the client. And clients themselves, and particularly in-house counsel who were surveyed, put confidentiality, raise it to the 3rd on the list, third most important thing. So clearly we are seeing even within the arbitration practitioners and those involved, there is a difference of opinion on how important confidentiality is. The ultimate users considering it to be more important than the other participants in it. And I think that gives rise to a little bit of the tension, Andrew, that you're talking about, and why there is so much clamor for there to be transparency in arbitration compared to confidentiality. I just have 2 points to make to that argument that is made by people who want greater transparency. The first is the reason why I believe there is transparency in court proceedings is because there is a wider public interest in knowing what the courts are deciding to be the law of the land. In purely commercial disputes between 2 companies or 2 individuals who have commercial interests, there is not that wider public interest. And of course, the taxpayer pays for the court, the taxpayer pays for the judge. Why should the taxpayer be paying to take up the time of the court to decide disputes between 2 purely commercial entities without any wider public interest? The second is arbitration awards don't have any precedent value. So unlike a judgment by, say, Brian when he was sitting, which would have a binding effect on lower courts or would be very persuasive to his fellow judges in the same level, an arbitration award by one panel has 0 value because firstly, it's not really available to any other panel. So there is no real interest from that angle, from the angle of precedent, to make it public. So there are good reasons why arbitration can stand apart from court in terms of confidentiality, and also a disparity within the users as to how important it is for them compared to participants who are not ultimate users. Andrew.
Can I pick up on 2 points there? You talk about arbitration and you stress between 2 commercial parties, but of course a lot of arbitrations are between, and I'm talking about commercial arbitrations, not investor state. A lot of arbitrations are between the state or an arm of the state and a commercial party. For example, if the state builds a hospital, builds a road, builds an airport. Surely, what is the answer to the point that there plainly is a public interest in seeing what that arm of the state did in connection with that project, which has resulted in this arbitration case being brought, let us assume, against it. Surely it's in the public interest to see what happened, how well or badly the public body behaved. Second point I mentioned is this: you say quite rightly, well, there's no precedent value in the decisions of arbitral tribunals. But of course, one of the points being made, and was made by the previous Lord Chief Justice in England in his famous speech a couple of years ago, was that where you're dealing with points of law, particularly if they arise out of contracts which are in wide use, if the points which arise are only decided in private by arbitral tribunals, then you don't build up a body of jurisprudence which could be very valuable for the industry. I mean, in the sort of cases I do, I see the same points come up arising from standard forms of contract, come up time and time again, and they're crying out for some sort of public discussion, public review of the decisions which have been made, but which of course remain private. So it seems to me that there is a good argument to say that there is a real public interest in having much greater openness when it comes to arbitral decisions, particularly if they involve a body of the state, an arm of the state. I wonder what your views of both of you are on that.
So you're absolutely right, Andrew, and it does not make, we'll talk about investor-state arbitration later on, it does not make complete logic for an investor-state arbitration proceeding to be public, whereas the same state entering into a road contract with a contractor, a dispute in relation to that being private. Of course, there is certain dissonance between that. The arguments used in favor or not in favor, but more to explain that is a state operates in many capacities. Where it operates as a public body having impact on the rights of more than one party, then its actions are indeed open to scrutiny as an investor-state dispute, or say a tenderer who loses a contract because of certain practices can judicially review the authority's decision to award a contract, and that's of course in the courts and it's public. But where it's in a purely commercial capacity, then those are not matters that are, say, in the public interest, whether that is right or not.
I understand that.
No, but that's the explanation.
I understand that, but you say when the state or the armed state is acting in a purely commercial capacity, yes, in one sense it's purely commercial, but hang on, it's spending our money. Why shouldn't I know what that state body there did to cause such a massive claim, for example, to be made against it?
Look, pausing there, and
Brian,
pausing there, Andrew, what's the basis of this public interest? Where do you draw the line? Is it purely in financial matters, or are you looking for other matters? Again, what is the starting point for public?
Well, why shouldn't the starting point be a presumption of transparency? And that is increasingly, I would suggest, increasingly is the starting point for civil society in looking at all aspects of state conduct.
But aren't you then transferring the merits of a dispute from the arbitral centre into the public domain, where you can get at least two variations of opinion?
What is there to be afraid of? What is there to be afraid of?
Well, here's
an example, if I may. Coming out of COVID in England, the state has entered into numerous purely commercial contracts for the procurement of PPE and so on and so forth. Similarly, with regard to Brexit, we know that the state entered into a fabulous contract for ships with a company which owns no ships. And that contract then had to be terminated at a cost to the public purse of some £30 million. Why should those matters, if they go to arbitration, be subject to public scrutiny?
Pause there. We know that in relation to COVID, there's going to be a full-scale and extensive public inquiry of some sort into the details of government action and methods, methodologies, and so forth, which were taken prior to and during the pandemic. Why should on the basis of transparency, all those arguments be exposed and dealt with in public, presumably, before that hearing, and perhaps influence them or be purposeless at that stage.
Well, that might apply to your point may apply to COVID, because we hope there is going to be a proper public inquiry, but to numerous other government contracts which go wrong, let us say, there isn't going to be a public inquiry. Then there's going to be very little information which gets out to the public domain, unless, as you suggest earlier, some people are brave enough to blow the whistle, to leak information.
Andrew, we are, of course, there are two sides to any arbitration, and you're looking at the side of the government, that is fair, public interest maybe in how the money is spent, but there's also a private party at the other end. And it may be it's really that protecting that private party's commercial interest that an arbitration clause is included, because the government can put out tenders without an arbitration clause. It's not the private party who's insisting on arbitration, it's the government who's insisting. And the reason for that is otherwise it may not get enough tenders at a proper price, because every commercial party is going to be afraid that tomorrow the government is going to act in a way that requires me to bring up a dispute, and then I go into court and then I have to open up all my books and all my tender information is out for all my competitors to see. I'd rather not get into it. There may be a purely policy reason behind putting arbitration clauses in these sort of contracts.
2 points. Firstly, commercially sensitive information can be protected, can be redacted from documents, redacted from judgments indeed, and it is. Secondly, you may be in a better position than me here, but I know of no study or evidence that has been compiled which says that if contracts between commercial parties and the state did not contain arbitration agreements, there would be a significant drop in the number of companies willing to tender.
There is at least anecdotal, I'm not sure, Andrew, you're right. I don't know if there is any methodical study like the Queen Mary University arbitration survey, but there is definitely impact from the users of construction contractors where they would stay away if there was no arbitration clause. Yeah, also impossibility of awards, that's also makes a big difference.
I can see why parties obviously would want to have a clause in their agreement which provided for a neutral panel or a neutral person to decide any disputes. I quite see that, and that's why, and because people may, rightly or wrongly, be concerned about being subject to the national courts of the state with whom they're contracting. But that's a different point from the confidentiality point. You can have arbitration without confidentiality.
Of course.
Japan has no confidentiality provisions.
Andrew, of course you can. But one of the points you make about redaction, you know as well as I do, how many hours and how much cost is expended in arguments over redaction in documents and so on.
Agreed.
And the other point is, where does your argument on transparency begin? Does it at what stage of any proceedings? You have to provide for it in advance of the proceedings, so you know precisely what sort of material is going to be exposed, who's going to undertake it, which is going to add further costs, and who's going to be responsible for it.
Well, it seems to me that we have a healthy disagreement here. If I'm reading the tea leaves correctly, neither you, Brian, nor Shourav consider it likely that there is going to be any significant greater transparency introduced into international arbitration, commercial arbitration, in the next few years.
But remember the background to the Lord Chief Justice's lecture and Lord Justice Gross. It was the fact that proceedings in the commercial court were dropping off, and the commercial court was worried about this, and they were trying to put the blame, or not trying to, but thought the blame might lie with arbitrations. And that was probably probably disproved. But there are sections in the business community who will be quite content, I'm thinking of the shipping side, be quite content to have some of their disputes aired in the courts, and it's the majority, it seems to me, of arbitration appeals and decisions come from that side of the community. And remember the quotation of which I think Peter Gross refers to, of Lord Devlin, that if you argue that the common law is being deprived of development because it's not having these interesting arbitration points before us, the logic of that is that when an interesting point arises, settling cases would be prohibited and would never be resolved. And I think it's a one-way street, and I think you're going the wrong way.
Let's move on to this question of parties being able to nominate an arbitrator. And so I think people who perhaps aren't that familiar with arbitration may be somewhat surprised when they hear that each side can choose, as it were, its judge, and then the judges choose a presiding judge, as it were, or if they can't agree, then usually an arbitral institution chooses the president or chair of the panel. And I recently read an interesting interview with Toby Landau, Queen's Counsel, who's eminent practitioner as both as counsel and as arbitrator in international arbitration. And I was quite surprised that he seemed to be very much opposed to the idea of party nomination. I'll just read you, if I may, just a few lines of what he said when he was asked about this. He said, look, the ideal solution is to have a high level neutral tribunal, but ultimately parties want to win, and to win means collecting votes on the tribunal. And so you start by securing your first vote, which is your choice of arbitrator. That's what the system has become, and that means you invest a huge amount of due diligence and time and money in researching the arbitrator to try and predict which way he or she is going to vote, and make sure that it's going to be in your favor. And the other side will then do the same. And he went on, that is a very different idea from that of a neutral tribunal. It's a tribunal that's stacked in your favor, and it puts a premium on how good your due diligence is and your ability to predict human nature. And that to me is a flawed system. That resonates with me, but I accept that people have different views on this. And just to be clear, he wasn't suggesting, and I'm not suggesting, that the person you choose, you nominate as your side's arbitrator, is going to deliberately side with you just because you nominated him. He's not suggesting that, but he's saying that look, this is a far cry from the idea, as I say, of a neutral tribunal. Brian, you've been obviously on both sides of the fence. You've been nominated, you've been counsel. What's your view on whether we can really continue with party nomination?
Is quite right. The system is flawed in this respect, but we all know it goes on, and it's been going on now since these 3 or 5 person tribunals were instituted. It's flawed because the hearing is going to suffer because it may not lack that degree of fairness and impartiality which the parties really deserve, and it's really reduced to a position whereby you might get a better outcome if you've done your due diligence and you've got a man or woman who is perhaps, and you can't guarantee this, you may be completely wrong, likely to be in your favor on balance than not. 2 things. Of course, first, the people who assist the parties, in which the parties cannot do without, are the high-level lawyers who have sophisticated databases and access to all sorts of information which is not available, frankly, to anyone else. And it's probably not even available to the various institutes that put forward their contracts and nominate in the event of disagreement. It's not available to them. So it is an aspect of these commercial arbitrations, and we're thinking mainly of international ones, which is to its detriment. It can get worse than that, because I've had experience where the degree of favor, if you can call it that, has gone a stage further. And that, of course, would be the wholly undesirable development. What the answer is, I do not know. In fact, I haven't heard any suggestions, any really convincing suggestions as to an alternative. I much prefer myself to have single arbitrator acting with the assistance of one or more assessors. But that won't prevail in international arbitrations, and I'm afraid it's a defect in the system which we're probably stuck with.
Shourav, your views on party nomination, and is it really something we're stuck with? What, how difficult would it be to provide that it should be the a particular arbitral institution which chooses the three-person tribunal?
So, Andrew, I think the reason why this is even a discussion is because the perspective of those who propose this are those who are looking at arbitration as an alternative to court, and therefore, if the court is an independent body not appointed by the parties, why shouldn't arbitration be? But if we shift the perspective to looking at arbitration as being along the continuum of how communities have resolved their disputes over the ages, long before courts were even in place, village elders were chosen but parties went to village elders. The parties asked somebody to mediate or arbitrate on their behalf. So party choice has been a part of private dispute resolution. The party choice of the decider has been part of private dispute resolution for a very long time. And if we look at it from that frame, then the court system is an aberration, not arbitration. So I guess it depends on which perspective you come from. In commercial disputes, if we also look at what an arbitration award is doing, it is not making law. It is trying to arrive at a just outcome between the particular parties before them, and therefore a party's comfort that its case has been properly understood, I think plays a lot of, has a huge role to play in its acceptance of the decision at the end of the day. If he felt that he had a fair hearing, particularly in international commercial arbitration, where there's pretty much always some sort of a cultural conflict between the one side and the other, that if you felt that you were heard, even if you lost, that you had a good opportunity to be heard and understood, people tend to accept the decisions more. Whereas if you put three completely unknown people in deciding the case, then their perception of have I had a fair hearing might be affected. So I would just make those 2 points. I think it's perspective and perception.
Okay.
Andrew, could I come in there? I think this brings us on to the point of persons nominated having to disclose any interest or connection with the parties who are putting them forward. And at what stage should they do that? I think that is desirable. If you extend the argument of third-party funding, the emphasis seems to me to be going in the direction of disclosure about connections, and I think that's absolutely right. And on my experience, I've noticed that the arbitrator nominated by the parties tends to be outside the area of the issues raised in the arbitration. They tend to be as far as possible, neutral people. You have former judges, former diplomats and so forth, who are introduced into this area. But it still doesn't remove the essential problem that if you're trying to nominate someone who, on balance, might be more favorably disposed to you, that's the name of the game.
Well, can I pick up a point you made a little bit earlier, Brian, which was in relation to the massive amount of work that is done by parties who've got the resources to do it in terms of researching potential candidate arbitrators, ploughing through everything they've ever said or done, anecdotal evidence as well, finding out from other parties how they behaved, what they said in other arbitrations, in order to increase their chance of getting someone who's going to see things their way. And it seems to me that certainly in some cases, there can be a great asymmetry between the parties. On the one hand, you may have one highly resourced party who can undertake that research. And on the other hand, a party which, for whatever reasons, doesn't have that resource. And that imbalance, it seems to me, only adds to the concern about party nomination. And I think one area where you see this in particular actually is in investor-state arbitrations, where there is a relatively small pool of arbitrators who get regularly appointed. And because investor-state decisions are usually, not always, but are usually published, one can see quite well what is the mindset, as it were, of a particular arbitrator. Putting it very crudely and oversimplistically, whether they are pro-state or pro-investor, and whether they believe in an expansive jurisdiction of the arbitral tribunal. And you see it there markedly, that one side, usually, perhaps exclusively, the investor, puts an enormous amount of effort into getting and nominating a person who they perceive with good evidence is going to favour their position, favour the investor position, as opposed to the state. And that, to me, and I think to outsiders who don't practice in this area, that just seems very much to undermine the legitimacy of the whole process.
I agree entirely. In this respect, I agree, I think, again, with one of Tomi Lando's points, that investor-state arbitrations might be replaced by some sort of administrative inquiry where proceedings were transparent, and the appointment of the person conducting the inquiry was again a transparent appointment, and that would be a much more beneficial and favourable outcome than the present situation in investor-state arbitration.
Sure. Well, any thoughts on the idea of having some, as it were, a neutral tribunal or inquiry looking at these types of points?
I mean, I still think, Andrew, that for commercial disputes, particularly in an international context, you have very often, as I said, a cultural mismatch between the two parties. Sometimes it is the party doing the work who is affected. Sometimes it is the host government that's affected. And for them to have no ability to determine who is going to be the final arbiter of the dispute, I think would take away from the attractiveness of arbitration. And once you take away from the attractiveness of arbitration, something else is going to come in to take its place. That's how life is. Mediation may come in. You now see, the Singapore Convention on Mediation last year, which is trying to give enforceability to mediators' decisions, or mediators' recommendations, or settlement agreements, almost as if they were arbitration awards. And that is really a move away from arbitration because people are fed up with arbitration of the cost and the inefficiency. So I think it's because party autonomy, and I know Toby Landau, QC, says that party autonomy does not necessarily mean your ability to choose your arbitrator. You could choose the institution who would choose your arbitrator. I see that point. But I think that's a very fine distinction for superb legal brains to make rather than for the man on the street. When the man on the street goes into arbitration, chooses a 3-member tribunal, he wants to be able to choose his arbitrator. And if you take that away from him, I think it will take away the attractiveness of arbitration as a method of dispute resolution. That's what I think.
You talk about the attractiveness of arbitration, but in the realm of investor-state arbitrations, there is an increasing body of opinion or body of persons who are finding investor-state arbitration deeply unattractive. And that is why you're seeing, and I think you'll correct me if I'm wrong, but India, for example, in the last few years, has basically either not renewed or has cancelled various of its bilateral investment treaties, which provide for investor-state arbitration. There are numerous other countries in South America which are taking a similar position. And part of the reason for that is, well, there are several reasons. One is the unaccountability of this 3-person tribunal, which decides issues which obviously have a significant impact on the public policy positions of the states involved and their ability to make decisions on public policy grounds or public interest grounds, which then get attacked, as it were, by investors who say that that has had an unfair effect on their investment. So you talk about the attractiveness of arbitration, but it seems to me that there is a growing movement, at least in investor state, which is seeing it as deeply unattractive. And it seems to me it's a combination, and it does involve, as part of its, as part of the issue, the very fact that people can choose and nominate an arbitrator who is known to have certain views.
Investor state arbitration, I think, is an aberration. I mean, it really shouldn't be there. And I'm talking about it from the perspective of one of the countries that you mentioned, who is withdrawn from its BIT, is not renewing them. Indonesia is another one of them. Investor state arbitration was the price these countries paid in order to be able to attract foreign direct investment. This was never something that they did really voluntarily. I mean, technically it's voluntary because you entered into a treaty, but it was really a lack of choice. Commercial arbitration,
I think, and I don't say this pejoratively, a lack of understanding of what they were letting themselves for.
Correct. So they didn't know, they knew it was a bitter pill, they just didn't know how bitter at the time. And investor state arbitration is now maybe 15, 20 years old compared to commercial arbitration, which is much, much longer. And investor state arbitration is dead. It is having looked at what nations face at the hands of tribunals, no country with a choice will go into investor state arbitration. And interestingly, that takes us into another discussion, because that has allowed the rise of China, for instance, in promoting infrastructure and FDI growth, because they don't demand this as a return for their investment, whereas the traditional Western countries did demand this in return for encouraging their citizens to invest. China doesn't do that. So I think the investor state arbitration, give it 20 years, 30 years after the sunset clause is over, I think it's pretty much dead. But commercial arbitration or interpersonal arbitration is here to stay for a long time, I believe.
I agree.
Can I pick up on a point that Brian made earlier, which I think you've just touched upon as well, Shourav, which is, Brian, I think you were saying, well, look, why shouldn't there in these investor state disputes be some sort of more administrative inquiry, which looks at the decision making and tries to resolve the dispute more as if it were an administrative law dispute rather than a commercial dispute.
Well,
I wonder whether part of where investor state has gone wrong is that it has largely adopted, as Toby Landau would say, the commercial arbitration model, but in respect of a dispute which isn't simply a transactional dispute between two commercial parties, which is something quite different altogether. To start with, the state isn't a party to some contract with the investor usually.
Well, in my view, state investor arbitrations have a limited shelf life now, and they started on the wrong basis because the parties were never on an equal footing. And I don't think anyone will spill any or cry over the demise of those. But in this connection,
the arbitrators who regularly get appointed.
Well, yes. But one other alternative worth consideration, the so-called escalation clauses, where you can have a provision for some sort of prior mediation or some kind of adjudication which falls short of full-scale arbitration, which might encourage the parties to come to some fair conclusion which avoids further costs, expense, and valuable resources so far as one of the parties may be concerned.
Yeah, and particularly probably would avoid these multi-billion-dollar awards, which certainly some people, raise an eyebrow or cause them to raise an eyebrow.
I declare my position, I'm not a fan of mediation, although I accept that it does have its benefits, but I think it operates in a particular area, but I can see it operating in that particular field.
Right, let's move on, if we may, to the question of diversity. Now, many of us, at least on this side of the pond, who practice in this field.
Can I interrupt you, Andrew? Maybe we're not a good advertisement for diversity here.
I was going to jump in. May I just jump in a minute, Andrew? I'm wondering whether there have been many comments, and I don't want you to look at the comments because the comment section is not a good place to look at right now, but there have been some questions and comments coming in. I was wondering whether the panel would be minded to address them, or maybe we could bring, I see Kristen has been making some comments. Can we bring Kristen up to share her comment?
For sure, and Kristen, in case Brian Knight and Shourav Lahiri don't know who you are, you might introduce yourself. I know who you are. But you're on mute, I think, so you need to be unmuted.
Yes, we've been muting
There
people.
we go. Thank you so much. This has been a really magical experience in more ways than
Kristen, if you can hear us.
Yes.
You keep blocking out. You keep skipping.
Oh dear.
Carry on.
Better?
Yeah, that's a little bit better.
Okay, my connection is a little unstable. So I am an attorney at law, and towards the tail end of a master's in international commercial. So I'm really excited by this talk. Just to start where you left off, Andrew, diversity in this field is quite an issue, quite a glaring issue. Some might say demonstrated by you guys, although the representation here is not as homogeneous. what, if anything, does the industry propose? And is this an industry problem, or is it that we're going to kick this back? The whole question of diversity, is it that we're going to kick it back to the principal actors, the litigants themselves?
Well, thank you, Kristen. There are many sides to this, but 2 points which arise quite a lot are, well, where does primary responsibility lie for the lack of diversity in international arbitration tribunals? And two not necessarily competing schools of thought, but one says, well, surely the arbitral institutions which make appointments, broadly, they make about 30%, I think, of all appointments. But the arbitral institutions who make the appointments, typically of the presiding arbitrator, where the parties' nominees cannot agree on the presiding arbitrator, there must be a responsibility on the arbitral institutions to act on the diversity agenda. And on the other side of the argument, it's said, well, hang on, yes, but 70% of appointments, roughly, are made by the parties themselves. And don't the parties themselves, therefore, obviously, share a large burden in terms of trying to effect some action on diversity? But others may have different views on where the responsibility lies. And then perhaps in a few moments, we can also consider, never mind responsibility, but what actual actions can be taken. And let me just throw one suggestion in there. When it comes to arbitral institutions, if there was what can be called standardized reporting across the different arbitral institutions, so that they identified at fixed points what, in terms of their appointments, what diversity there was. If there was some year-end general report, if there was a statement as to intention, perhaps as to targets, and then one could compare different arbitral institutions. How does the ICC compare with the HKIAC or with the LCIA, the London Court of International Arbitration, and so on? And that would allow parties who care and want to engage on this, at least at the contracting stage, perhaps to make a choice as to which arbitral institution should govern, as it were, any arbitration which is launched. And so you might say, well, let's go with X arbitral institution because it's got a much better record on diversity. But let me throw that out perhaps to Shourav and Brian. Brian.
Sure, Andrew.
Shourav, you go.
So, shall I go?
You go.
Yeah, okay. In my view, it probably doesn't accord with the views of a lot of people, but maybe I have a little more freedom to say it because I guess on this panel I am the diverse actor, so I can talk about it. I think there is an unfair focus or shifting of burden onto the arbitral institution by the participants in arbitration. And it's almost because the arbitration institutions don't really have a voice, because they can only act when everybody else fails to act. They are not the primary actors in any arbitration. In fact, you don't even have to check with an arbitration institution, can I use your rules, before you write them into the contract. So they're a complete silent party, an involuntary participant in an arbitration. Most of them very happy to be involuntary participants because there is a fee associated with it, but ultimately their scope of responsibility is very limited. I believe people are not taking the bull by the horns and saying it is me, the user of the arbitration, who needs to deal with this. And ultimately it is the client and their advisors who are in prime position to influence this going forward. And of course, diversity has many aspects. There's gender diversity, there is ethnic diversity, age diversity, all of these. And they all have different considerations. There are different pushes and pulls in each of them, some more important than others. I think gender diversity is something that huge advances have been made, but that's also because we started from a very low base, and therefore the percentage increase seems remarkable, but you know, that just shows how bad we were. Ethnic diversity, I think, still lags very much behind. Age diversity, I don't think it should even enter into the equation, because you know, when you want people to decide your disputes, you want them to have enough experience of the world to decide your disputes. So putting a very young arbitrator in there to meet a quota of age diversity, I think, goes against it. Also, that person has very little influence on the rest of the members of the tribunal. So different diversity issues have different demands, but I think the prime responsibility of this falls with the parties and their legal advisors, and it's they, in fact, who are pushing this onto the arbitration institution. You know, Andrew, you mentioned a factor of 30%. Arbitration institutions make appointments. I think maybe it may be even lower than that. They actually are only making appointments in the rare case where it's a single arbitrator and nobody can agree, or where parties or their appointed arbitrators can't agree. So they don't move the needle all that much. But of course, it's very easy to assess how they're doing because their statistics are available, whereas it's not very easy to assess what parties are doing. I think the primary responsibility must be with the parties rather than the arbitration institution.
Brian,
I don't disagree with that last point. In fact, I agree with it entirely. I think the starting point is that the primary responsibility lies in the hands of the parties. If they want to have an arbitrator which is or who is more susceptible, is more open to diversity, then they are able to agree on the appointment of such a person. And that's again subject to Shourav's point about the experience and so forth. And to that extent, the parties can take the responsibility of a choice of arbitrator out of the hands of the institution. The problem then becomes, will the parties agree? And I think that's going to be the core of the problem. And if the parties don't agree, or back to square one, someone else has got to appoint. There is a degree of responsibility on the institutions that promote arbitration and arbitration mechanisms to do as much as possible. Organisations in the UK, such as the Chartered Institute of Chartered Surveyors, run very extensive international courses, and they're rooted in diversity. External help is available, for example, the ERA pledge, the African promise, but there are limitations on the influence which that kind of pressure can produce results. I think one comes back to the essential point. If you're going to resolve or attempt to resolve your dispute by private arbitration, then if the parties can't come up with an agreed arbitrator, you're back to the institution. That begs the question, is there a sufficient pool of arbitrators available for the parties to come to a decision? Yeah, which comes first?
There may be a chicken and egg situation
exactly.
there, but Chrislyn Moore, I think you wanted to come in there. Chrislyn? No? We may have lost Chrislyn again. But for Brian, there really is a chicken and egg position here, isn't there?
Yes, I think so.
And if you say, well, look, it's the party's responsibility, well, of course, in one sense, that's absolutely right. They could say, I'm going to appoint a diverse, as it were, arbitrator. But you then say, and the point you've just raised, well, the pool is relatively small. If you look, for example, at the number of African arbitrators who've ever been appointed in disputes which relate to something in Africa, you are dealing in very small single figures, percentages, very, very small. To say, well, look, the pool is so small, it's almost a self-prophesying argument, isn't it? Isn't that why there is force in the argument that the arbitral institutions, once the parties haven't been able to agree, really should take, as it were, positive steps to ensure greater diverse representation?
I agree. I think there's a huge responsibility on them, and I would like to see them actually promote and bring into the public domain what they're doing to achieve that. And in connection with that case in America, which received a lot of publicity, the JZ arbitration.
JZ, we call it.
JZ, sorry. I know speed on that. One phrase stuck in my mind.
We should perhaps remind people what happened in that case.
Yes, please do so.
The facts are not fully reported, but my understanding of them is this, that JZ was on one side or the other to be involved in an arbitration with an American company, the arbitration to be held under the auspices of the American Arbitration Association, the AAA.
Yes.
And a list of potential candidates was provided by the institution, all of whom were white. And Jay-Z went to the Manhattan court to seek an order, in effect, staying the arbitration until the American Arbitration Association could come up with a list which contained at least some, quote, suitable African Americans. And now the judge actually did sort of stay the arbitration to see if the parties could work out a deal. And ultimately, apparently, the American Arbitration Association did come up with some names which I think satisfied Jay-Z. But, you know, in one sense, one says, well, why isn't that right? Why shouldn't someone be able to stand up and say, well, look, this list you're giving us, or this person you're proposing, you, the institution, are proposing, isn't an appropriate person because it bears no, the person has no connection with or apparent previous experience with the locale from where the dispute arises, or from the culture from where the dispute arises, and so on. What's bad about that? Put it that way.
Well, I agree. You see, I think positions get polarized in a sense. There is, I think, a strong movement, which I personally support. I remember I had the first pupil of color in chambers, and to say I was proud of it is wrong, but I felt absolutely right, and I think matters improved after that. But I think while people are pressing for greater diversity, greater choice, on the other side, you hear expressions like, well, we don't want to turn alternative resolution dispute into an alternative diversity dispute. That's an expression I dislike, and I don't want ever to hear that, because that's not the point of it. The essential point is that the parties get someone who they think is going to give them a fair hearing.
I think the discussion has to be broader than that. I think you have to build in a win for diversity into the system, and that is not built in now. So going back to your Jay-Z example, Andrew, the reason that he was handed a pool of all white potential persons is because the pool is dominated by that geographic. And the reason the pool is dominated by that geographic has to do with who is available to this industry, who does the industry encourage, and who does the industry attract. And that itself has to do with issues of money, it has to do with issues of privilege, it has to do with issues of access to the field and to education. I mean, it's a pretty obscure field, believe it or not. So more, to me, more has to be done to remove the kind of tokenism in this area that I see as a Black female person from the developing world. It cannot simply be that we are told, well, it's on the litigant to choose, because the pool that the litigant is given to choose from does not look like the litigant. And he then says, well, if this is what it is, what am I going to do? Am I going to put my dispute on hold and train somebody to do my dispute? That can't work. But I know the diversity question is a huge question. I want, if I can, to talk a bit about this industry, to ask about this industry and the pandemic. And if you gentlemen who are so, who are buttresses in this field or bulwarks in this field, if you foresee that because of the pandemic, governments will make an attempt to expropriate, as it were, without compensation, by invoking the pandemic as a necessity defense. Is that something that you think you will see in the coming years?
Shourav, you've looked recently at the effect of the COVID pandemic. I think you've also considered how that might play out in investor-state issues. What's your response to Kristlyn?
So, Kristlyn, you raise a very fair point, and traditionally the kind of expropriation that we have seen in that leads to disputes are those that somehow relate to the natural resources of a country. And of course, international law or the BITs that develop that law do not disallow expropriation. It just says you can expropriate with due compensation. So every state has the right to take back what it has given, provided it makes the person affected whole. Necessity, as you rightly point out, is a ground on which expropriation can be justified. Public health, for instance, is one of the grounds on which expropriation can be justified. And if a country is acting in the interests of its citizens, then yes, the pandemic does provide them an opportunity to expropriate. If I use the word opportunity not in a pejorative sense, but a situation where they can expropriate. But it is not so simple. I think it's you can't willy-nilly do so, because I think one of the earlier questions in the chat was about the precedent value of other decisions by ICSID arbitration decisions or investor state tribunal decisions. They are all available. So there's certain very clear principles that apply, which would apply also in a situation of a pandemic. And you can't just utilize the pandemic as an excuse. But definitely, if it's a public health situation that requires you to take certain legislative measures that may be considered as taking away the rights of an investor, we could see that coming up. I haven't seen anything come up more recently on this, but I guess the chapter is yet to be written on this.
Yeah, I'm certainly. I'm not aware of any proceedings having been commenced, but I'm aware of numerous articles on the on the web, predicting that there is going to be an avalanche of investor state claims arising out of the pandemic. And you're absolutely right, Shourav, when you say, well, of course, where measures are taken for public health purposes, etc., that may provide a defense, as it were, to the state's actions. At the level of principle, general principle, that is, of course, true. But the devil is in the detail of these things. And the opportunity, especially where decisions are taken quite quickly, certainly in England, it may be different in Trinidad and Tobago, where I think you are at the moment, Chrislyn. But in England, decisions are being taken at 11 o'clock at night, announced on the radio at sort of midnight, with no consultation, etc., or very little consultation. And where decisions are taken in that sort of context, there is much greater scope for being able to criticize the decision-making process, and criticize it in such a way that it may allow the investor to say that his rights have been trespassed upon. So no cases I know of as yet, but as I say, a lot of predictions that there are going to be masses of them.
And one more point, Andrew, if I may just add in, Chrislyn, is an important part of investor-state arbitration disputes is unfair treatment. So if everybody in society is affected in the same way because of the midnight resolution, then I think there is less opportunity for an investor to say that he has been singled out for unfair treatment, or his investment has been particularly affected deliberately by the government, because everybody else's investment is similarly affected. And in those situations, I think countries, governments have a big cushion as a result of the pandemic.
Christian, could I come in? I wasn't clear, and that's my fault, what particular situation you had in mind, and if you could just enlighten me about that. And my next question is, it was linked with the availability of appropriate persons to decide that dispute. What's the connection between the two?
Chrislyn is muted at the moment.
Can you
Unmute.
So we may have missed what you said for the last 30 seconds, Chrislyn.
Unmute. Thank you very much. Brian, I was, if you're regarding my last question with regard to expropriation, to the pandemic, yes. So I was thinking perhaps of a situation where, let's say we grab your hospital or your drugs in the middle of the night and say, look, you know, you can't export perhaps because we need it nationally. And so there's this health emergency. But my perhaps devilish concern was, okay, yes, I know we can expropriate, we may have justification, etc. But is that a scenario, or is there a scenario where we could say, well, we're not going to compensate you because, you know, this was over and above an emergency? I know the case law says, well, yes, expropriate, and that is necessarily attached to a compensation. But can we walk away in this scheme of things? Can a government make an argument that we can walk away without compensation?
Well, first of all, if a dispute of that sort would presumably be decided in the domestic court of the country. So you'd be thrown back upon whichever adjudicator, if I can put it that way, you got. And you may think that he's unsympathetic or she's unsympathetic or not. But that was what I was not clear about. And the second point is that I think that in so-called Western democratic societies, defences to expropriation dependent upon, for example, the COVID pandemic, are going to be run, if only because governments will have spent so much money, they don't have much more left to compensate people who've been victimized. So I think you'd be confident that that sort of defense is going to be run.
I look forward to it. It seems to me to be quite exciting. And Andrew, I have seen some of those articles that predict that this is just there's gonna be an avalanche of these cases. I think the articles are all coming from the trade, so it seems a bit like wishful thinking from the part of participants in the industry. Like, bring it on, you know, we can't wait.
Well, you're right. Obviously, that a lot of those articles are written by law firms, and as you say, it could be interpreted as meaning phone us now. Let's start working on this claim. But there are some other articles written by some NGOs, which, for example, are suggesting that there should be an internationally or regionally, if not internationally, agreed position by states, declaring in effect that they're not going to entertain investor-state claims against them for actions taken to try and deal with the pandemic. Now that itself obviously raises a mass of questions as to what would be the legality, the effect, and so on of such declarations. And I'm speaking for myself, I don't think what I can say any more than sort of watch this space. But as you say, I think it's going to be quite interesting. Just picking up Brian's point about, say, a company in Trinidad and Tobago being told, well, you can't export your drugs. If that drug company was the subject of an investment by a foreign investor, then I think one might well find oneself in the investor-state international arbitration territory, yes, rather than national court. As ever, all these things are fact sensitive and fact specific. Can I throw in, I'm just slightly mindful, or very mindful of the time, but throw in what I think is a potentially related issue here. And that is the question of third-party funding in international arbitration, and given that we're talking about it, international investment arbitration. Because there have been numerous and well-documented cases of what are, I think, referred to as vulture funds, buying up, as it were, the right to make a claim that exists in another person, and then pursuing usually a developing country with enormous energy to try and then reap the benefits of the award that the original investor had decided not to pursue. And then on the pure third-party funding front, we have obviously these increasing number of funds being happy to provide the finance for claims on the basis that they will get a percentage of the return. So their interest is, in a very absolute sense, purely financial. Now, many years ago, in fact, not that many years ago, it was in the mid-60s, until the mid-60s in England and Wales, third-party funding wasn't allowed. Until I think a couple of years ago, Shourav, it wasn't allowed in Singapore and Hong Kong. Now it is. And it seems to me that is, well, I'd be interested to hear your views on this, whether this is a positive thing or a negative thing, but it certainly is, it has the potential to lead to a greater number of claims being made, but perhaps coming out of the COVID pandemic, whereby, you know, a purely financial decision is made by the funder that this is something worth putting some money into, because we'll take 50% or whatever it is of the winnings. I'm not sure whether that is a positive step, although it looks like third-party funding is here to stay. A bit of a rambling question that. Brian, third-party funding, good, bad? Anything we should be doing about it? Should it be subject to some limits?
I think it's with us, and I think it's here to stay, and it's going to be exploited. And there's insufficient regulation of it, but I think partial ways of dealing with it, such as getting either the parties to disclose or counsel to disclose, and I think there's a difference between Singapore and Hong Kong on this. I don't think go anywhere near the problem, because if, as a matter of policy, and it might come back to go to policy eventually, if it's policy that you discourage activities such as this, then
third-party funding.
Yes, a simple disclosure of the interest isn't going to take you very far. On the other hand, if you seek to restrict third-party funding in any meaningful way, you're going to deprive litigants of the opportunity to prosecute their claims. So I'm afraid it's going to be with us. And the question is, to what extent is it going to be regulated, if it should be regulated?
Shourav, what's the your view on this?
I'm conscious about the last minute.
What's the extent of regulation in Singapore? I know they've passed some laws dealing with third-party funding, not just making it legal, but I think seeking to regulate it. England,
no,
as
it is permitted in arbitration.
Regulating third-party funding.
Yeah, it's permitted in arbitration. Same in Hong Kong. And really, why jurisdictions like Singapore, Hong Kong are getting onto it is because other jurisdictions are, and they don't want to lose the arbitration business that would be associated with third-party funding. I mean, third-party funding is just it's purely an asset class. If you look at it from the perspective of financial investors, a dispute is just another asset class, just like mortgages may have been in the US in 10 years ago. And so it's just a new opportunity to get a return. The reason why a lot of people are uncomfortable with it is because historically, this area of legal dispute resolution has been immune to purely financial motive, purely. I mean, of course, it's motivated a lot by financial returns. Contracts are motivated by financial returns, but purely financial returns of unconnected observers who have no stake in it, really, apart from financial one, is foreign to the law. But as Brian says, this is a one-way street. There is no turning back. It is going to increasingly happen. And it happens both for litigants who are not in a position to finance their claims. This is good for them. It is good for companies who you want to take the cost of arbitration off their balance sheet and get somebody else to bear it. So why shouldn't they, if they could take a loan from a bank and pay interest, why shouldn't they be able to do so? The problem in investor state arbitration is a little more stark, because the return compared to the investment is significantly different. Because the potential awards in investor state arbitration are in the tens and hundreds of millions, and therefore the cost of running an arbitration, which may be a few million, is small in comparison. And that's why you see more of that there. For instance, in construction disputes, you see hardly any in third-party funding, because it's so difficult to predict what's going to happen for somebody to take a punt. So that's really in summary what I would say. Andrew, I'm conscious I'm 2 minutes over the time.
Andrew, just can you hear me?
Yes, Varun.
So just one further point. And if investors take a punt, then they take the risk. And if they take the risk, they can insure against it.
Well, indeed. I think in some countries there are regulations which require the third-party funder to not to limit, as it were, the extent to which they would be answerable for the other side's costs or for adverse costs orders and the like, which I don't think we have anything like that in England as such as yet.
But there is, I understand, a funding system called portfolio funding.
Yeah.
And that can result, I understand, in economic losses because of the way in which the cover is distributed. Now, it's not an area in which I really know much about, but it does seem to me that it might, in itself, give rise to supplementary litigation as to the fair operation of such schemes.
Yeah, because those schemes work by, instead of the funder funding one particular case, they provide, I guess it's a pot of money, as it were, across the whole range that a law firm, for example, range of cases that a law firm rather than an individual company might be involved.
Or a party may cover the number of claims of a party. But yes, I mean, there's single cover, which law firms take out, which is not a system of funding. But the portfolio is a variation on that.
Gentlemen, this has been a rich and stimulating discussion, but I'm looking at the time. And would this be a good place for us to...
Margaret, we're just getting into the...
I realize to cut off you. But what I do want to say is that I really would like, if you'd allow me, I would like to thank you, Brian and Shourav and Andrew, for leading this discussion, which was not only rich, but so broad, you know, covering so many issues: confidentiality, third-party funding, party-nominated arbitrators, and diversity, which I thought was quite a stimulating discussion. And it was really great to hear the different points of view on all of these 4 areas. And although the panel could have been more diverse, I would like to thank Ms. Chrislyn Moore, former Minister of Justice of Trinidad and Tobago, who happened to be here.
Yeah.
And, yeah, so this summit is diverse by design. And so this kind of dialogue can be stimulated because of, you know, how we've designed this summit. So really appreciate you as well, Chrislyn, jumping in. I wish we had more time for others who have been commenting to ask questions of the panelists, but there wasn't much of that. But I hope Chris has done them well by representing the audience. So I don't know if each of you wanted to give one line or 2 to close this discussion on trends in arbitration.
Yes, can I say this? Christine, if you haven't already been an active arbitrator, I hope to read in the very soon future that you are. And you have many arbitrations.
Yeah. Well, I'll just sign off by thanking Brian and Shourav for giving their time and for making this such a, I think, quite interesting and stimulating discussion. And obviously to thank Future Law for setting this whole thing up, and to thank Chrislyn Moore for joining us and putting these other tricky questions to us, which we probably fumbled over the answers of.
Thank you, Andrew.
Goodbye.
Thank you.
That is goodbye.
Thank you, guys.
Goodbye.
Bye.
Bye.